Welcome to Tomkins Talks. It's time for another summary of a recent case in a short, snappy way that's easy to digest, whether you're at home, in the office, or on the move. Now, some of you may have noticed last week that there was a rather important judgment handed down. I'm not talking about the verdict in the Wagatha Christie case, but I'm talking about a verdict in a case which affected all sorts of high streets across the country, just like this one behind me now. And it's the case of Bank of New York Mellon and Cine-UK. So I'm going to head into the office, and when I'm there, I'll get started with the backstory. This case concerned a cinema in Hengrove in Bristol and was heard by the Court of Appeal at the same time as a matter concerning the London Trocadero on Piccadilly, which involved very similar facts. In short, both tenants operated cinemas that could not run during the pandemic due to the various restrictions imposed by the government. In view of this, they ran defences to claims brought by their landlords for rent arrears, relying principally on three grounds. The first ground that the tenants relied upon was that the rent should be suspended for any period where they were unable to occupy and use the premises as a cinema, for example, during the COVID-19 pandemic. The second ground they sought to rely upon was that there was a failure of consideration between the parties on the basis that they had been unable to use and occupy the premises for their permitted use as a cinema. And the third ground that was run in one of the cases was whether the rent cessor provisions within the lease were sufficiently wide to mean that the rent should be suspended whilst they were unable to occupy for their purpose as a cinema. Now, when the landlords issued their claims, they sought summary judgment on the basis that the tenants had no reasonable prospect of defending the claims, and they were successful. The tenants appealed, and the matter was heard in the Court of Appeal. So what was the outcome? In short, the outcome was not a positive one for the tenants, as all of their arguments were unanimously rejected by the Court of Appeal. The court held that there was no basis to imply a term into a lease, there was no failure of consideration, and the rent cessor clause was not sufficiently wide, as it required there to be physical damage to a premises prior to the rent being suspended. So what does this mean? This is clearly good news for landlords, but not so for tenants. Let's face it, over the past couple of years, tenants have thrown the kitchen sink at landlords who have tried to claim rent. They've run all sorts of arguments, and they have all pretty much been defeated. This means that, as far as I can see, tenants are not going to have lawful defences to resist the payment of rent that is due. And so if I were acting for a tenant now, I would be strongly advising them to consider putting matters into the arbitration scheme, as I think that's the only basis on which they might, and I say might, obtain a better outcome than if the matter was to go to court. I hope you found this useful. If you have, please comment, like or share. I'll see you again soon for another Tomkins Talks.